Press freedom has been highlighted time and time again as fundamental to democratic societies and to human rights. We have already seen how in the 18th and 19th century, political commentators of the time hailed it as essential to societies, truth, governance, and how international and regional courts have identified press freedom as a founding block of democracies. And yet, rarely a day goes by without a report about infringement on press freedom, be it newspaper, television, radios, online media, or individual journalists. In this segment, we will seek to achieve three objectives. First, we will identify the current threats and challenges to press freedom. In a second part, we will review quickly some of the main arguments for press freedom. And thirdly, we will highlight the main principle that should guide any state intervention and interference with the media. Let me begin with some examples. In 2015, a friend of mine, in fact, a colleague, Khadija Ismailova, was charged with embezzlement, tax evasion, and abuse of power. She was convicted to 7.5 years in prison. Khadija is an investigative journalist from Azerbaijan, a recipient of the Alison Deforge Award for Extraordinary Activism and of the 2016 UNESCO Press Freedom Prize. She has covered corruption and abuse of power by the authorities and her country's ruling family. Another example, Radio Caracas Television, one of the oldest television stations in Venezuela, was highly critical of the former president of Venezuela, Hugo Chavez. It was denied a renewal of its broadcasting license in 2007. The government released a 360-page report in March 2007 which accused Radio Caracas of insulting the authorities, inciting rebellion, and failing to pay taxes. In fact, the troops of Venezuela seized the channel's broadcast equipment in May 2007. However, the Inter-American Court held later on that the TV channel's shutdown was politically motivated, and it called for the reinstatement of its license. These two cases illustrate the political interference of the state with the practice of journalism and the manipulation of the law and of the judiciary to silence journalists and independent media. In some countries, journalists as well as media outlets are held on bogus charges related to tax or finance. In others, they may be charged under law regulating the press or regulating freedom of expression. These charges may not result in the loss of life, but they may result in the imprisonment of individual journalists and the censorship, shutting down or banning of media outlets. According to the Committee to Protect Journalists, 199 journalists were imprisoned in 2015. Of those behind bars, the majorities were online journalists. More than half of those imprisoned were so on anti-state-related charges. Countries imprisoning journalists included China, Iran, Vietnam, Ethiopia, Egypt, the second worst jailer of journalists worldwide, Turkey. Government repression and abusive control, usually through the manipulation of the legal and judicial system, are usually not resulting in the loss of life, but the killings of journalists are all too real. According to press freedom organizations, between 67 to 71 journalists were confirmed killed for their work in 2015. The deadliest countries for journalists were first and foremost countries at war, including Syria, Iraq, Yemen, South Sudan. This is a pattern that has been well established for many years now. Countries at war are particularly deadly for those reporting on the conflict. But the list increasingly includes countries which are well established or new democracies. So, for instance, in 2015, some of the countries with the largest number of killed journalists include France, Brazil, and India, confirming a trend that has also been reported for close to a decade now concerning the killings of journalists in nominal democracies. In 2015, France stood out of the list because of the attacks on Charlie Hebdo, and by so doing demonstrating the reach of non-state terrorist groups. Government legal repression and the killings of individual journalists and bloggers are occurring alongside newer threats and challenges to the media and press freedom. The digital revolution, and in particular the development of social media and of new forms and sources of information, has meant that the business model of traditional media is largely under threat. Advertising does not bring the revenue it used to bring, while the number of paid readers has sharply decreased. Altogether, this has resulted in media outlets closing down, reducing their scope and activities, particularly investigative journalism, or turning to new owners. Indeed, a phenomenon experienced in many parts of the world is the one that has been referred to as media capture. By this is meant the capture or control of the media by businessmen or politicians keen to own media as an important tool for influencing public opinion and or promoting their business interest. In certain countries, the much-needed transformation of government-owned media outlet has created new opportunities for political or business elite to buy media outlet with the view of advancing their own political or business interests with little to no regard for the public interest or their right to receive information. Whether traditional government repression, control over the media by political or business interest, or at worst, killing of individual journalists, all of those developments threaten press freedom around the world. As I have highlighted in a previous week, courts around the world as well have time and time again insisted that the media as a whole merits special protection. The United Nations Human Rights Committee has stated, the free communication of information and ideas about public and political issues between citizens, candidates, and electoral representatives is essential. This implies a free press and other media able to comment on public issues without censorship or restraint and to inform public opinion. The arguments advanced in defense of freedom of the media have been over the years, in fact over the last 2 centuries, pretty consistent. 1. The media gives the public access to information and ideas on matters of public interest, thus allowing the public to form opinion. In 1957, the US Supreme Court explained in Roth versus the United States that the protection given speech and press was fashioned to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people. 2. The media is best equipped to advance the public interest. The Supreme Court of India, in a 1985 case regarding an excessive newspaper tax, reaffirmed the key democratizing and social justice enhancing function of a free press. It stated, and I quote, "In today's free world, freedom of press is the heart of social and political intercourse. The press has now assumed the role of the public educator, making formal and non-formal education possible in a large scale, particularly in the developing world. The purpose of the press is to advance the public interest by publishing fact and opinion without which a democratic electorate cannot make responsible judgment." That statement could apply with even greater strength to the online world and online media. And thirdly, another argument for press freedom is that the media plays a vital role of public watchdog, strengthening democratic governance. Freedom of expression constitutes one of the essential foundations of a democratic society. It is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that often shock or disturb. We've already heard that. It's coming from the European Court. But it goes on to say that these principles are of particular importance as far as the press is concerned. While the press must not overstep the bounds set inter alia in the interest of national security or for maintaining the authority of the judiciary, it is nevertheless incumbent on it to impart information and ideas on matters of public interest. Not only does the press have the task of imparting such information and ideas, the public also has the right to receive them. Were it otherwise, the press would be unable to play its vital role of public watchdog. I was quoting here from the European Court. On the other hand, the media is not always a benevolent actor in our societies. Journalists themselves, observers, experts, but also the public, have raised concern regarding the politicization of the media, its capture by commercial and business interest, unprofessional or unethical journalism, the lack of diversity of viewpoints. The media may be censored or silenced by the state, but it can also be the actor censoring others. So how do we balance these critiques with the centrality of press freedom to democracy? That is the point of media regulation. Finding a path, navigating those tensions, allowing the media to deliver the best outcome for society and for press freedom. Regulation of the media is a normative, legal, and policy framework for the media to guide and regulate its behavior and the behavior of other actors influencing the media. There are many ways through which the regulation of the media is conducted. The first and evident one is that the regulation is done through a number of laws, many of which are meant for all actors of society. For instance, the media, along with other actors, has to pay taxes or to comply with the defamation laws. Other laws may be specific to the media or the practice of journalism. They may include, in some countries, broadcasting laws. They may include the law that establish the regulatory body and framework for the regulation of the media, and I will return to what this body entails later on. Regulation, particularly of broadcasting, radios and television, is also done through the media regulatory bodies, which are responsible for enforcing some of the laws, allocating spectrum for radio and television broadcasting, developing standard and rule of behaviors for the media, enforcing them, and ruling over dispute and complaints from the public. If and when these legal measures interfere with and limit press freedom, they must meet the three-part test of legality, valid ground, and necessity that we have discussed in a previous week. In addition, media regulation may be done through non-legal and voluntary schemes. This is usually referred to as self-regulation. It is initiated and done by the media itself, meaning journalists, editors, owners, to ensure that the media follows and endorses professional and ethical standards, and to address dispute between media or between media and the public. This kind of scheme, self-regulatory scheme, usually involve drafting a code of ethics or a code of conduct and agreeing the procedures and mechanisms which will be followed in case the code is violated. For the print media, and this may include digital media, there is an overall agreement that this form of voluntary regulatory scheme, so self-regulation, is the best system for press freedom. With regard to the broadcast media, it may be more strictly regulated through a regulatory body established by law in order to manage the limited available spectrum. In addition, media regulation may also include positive measures taken by the government to support the media, particularly in a difficult economic environment. So that may include, for instance, providing the media with tax breaks, with subsidies over papers, and so on. Altogether, any regulation of the media enforced by the state or voluntary must seek to ensure and promote three principles which applies to all kinds of media. Pluralism, very important principle at the heart of press freedom. What does it mean? It means that the public should have access to different types of media owned by different people. Why does it matter? Well, to prevent information to be dominated by one source only, one newspaper, one radio, one television, and in general what this means is that it's one person or one political party that dominates the media landscape. A second principle at the heart of media regulation is that of diversity. It means that there should be a variety of information and viewpoints heard and read. It means that not only a privileged few can exercise their right to freedom of expression through the media, but that the media should really consider giving access to a very broad range of individuals and viewpoints. That is essential to a free society. The opposite situation, where the media is dominated by one person or a very few number of persons, breaches not only the right of those who are denied the ability to access the media, but also the right of society as a whole to be well informed and to receive information from a variety of sources. That's a very important principle and, of course, a difficult one to apply. But the diversity of viewpoints on the media and through the media is an important principle behind media regulation. And finally, the third principle is that of independence. I think it goes without saying. What it means is that the media should be permitted to operate independently of government or other control. For instance, there should be full editorial independence. This will ensure that the media plays its role as a public watchdog and that the public has access to a wide range of opinions, especially on matters of public interest. This has important implications for media regulatory models and for the way state can or cannot intervene in the way media are operated, but it also has important implications for the way media owners should or should not intervene in the running of the media and in the editorial independence of their team. In conclusion, we have reviewed the principle behind the importance of protecting press freedom and what this protection means in practice, with a specific focus on regulation through diversity, independence and pluralism of the media. In the next segment, we will learn how these principles are implemented with regard to the written press and to broadcasting.